Well, thank you. I'm very honored to be here. When I learned about ties, I thought I'm not by training a scientist. I, in fact, had a discussion with Richard Dawkins one time. I said, I'm an attorney. I said, I hope you don't hold that against me. And he said, I do actually. But I've spent most of my career, when not in the military, as a prosecuting attorney. And of course, modern forensic science is extraordinary, particularly DNA and other advances. Years ago, I got interested in the case of the so-called monkey trial of 1925. And in the last few years, I've done some presentations. I'm an adjunct professor at the Indiana University School of Law. And I decided to do some presentations based on looking at it as a trial attorney, because it's a fascinating case as a trial attorney. So I will try not to get into the weeds, as they say, too much on the details of the law necessarily. But what I want to do tonight is just do an overview of how this extraordinary trial came to be and its significance today. I've got two quotes up there, one from William Jennings Bryan, three-time American Democrat candidate for president, failed, served as Secretary of State, renowned politician from the turn of the century. He was a man who really changed the Democrat Party from being the most conservative party in the nation to being an actually rather progressive one. But he himself was a very strong Christian, very strong evangelical, and his comment about this was his quote: "The contest between Christianity and evolution is a duel to the death." His counterpart, known as a free thinker, agnostic, atheist, quite the fighter in the courtroom, quite pugnacious. Clarence Darrow announced about this when his client, John Scopes, the teacher in Dayton, Tennessee, Clarence Darrow said, "John Scopes is not on trial. Civilization is on trial." So I hope you can see from the quotes from these two great men, these two great attorneys, um, how people viewed this strange trial in 1925. The phrase trial of the century gets thrown around quite a bit. Leopold and Loeb is a famous one, 1924. Two very rich, very intelligent, privileged young boys kidnapped and murdered a child. Darrow represented them and they got life in prison, but they didn't end up being hung. And that stunned most people, but it launched Darrow to national prominence. A few years later, the Lindbergh baby kidnapping, of course, in 1932. You had the Manson family murders in 1969. I'm old enough to remember those. Of course, O.J. Simpson in 1995. But as a trial attorney, I say the real trial of the century is the state of Tennessee versus John Scopes in 1925, because we're still debating these issues today. It's remarkable in 2024, we still have this debate going on about how evolution, how science should be taught in the public schools. And so that's why I think this is the real trial of the century. And I hope for those of you who are scientists or science teachers, this will help illuminate a little bit some of the politics that's made your profession sometimes rather difficult. I have a degree in history from Indiana University, and one thing that struck me about humanity is we are always asking the question of our origins. Every society, every tribe, every culture has origin stories, most of them grounded in superstition, and most of them accepted because for centuries, most human beings were illiterate. They were poorly educated. I had a chance, I've served in the Army in Iraq and Afghanistan, I've been in Haiti, I've been into some countries with real poverty. And I see this connection between poverty and superstition. Ignorance is the soil from which superstition grows readily. And so for centuries, religion answered those questions until really the late 18th and early 19th century. You began having challenges even earlier than that. Copernicus and Galileo and the like came up with the heliocentric theory of the solar system, which challenged the church's position that the Earth is the center of the universe. Paleontologists in the 18th century, that was becoming a new science. You had geology that was coming as a new science. And then, of course, Charles Darwin in the first half of the 18th century goes on his 5-year exploration around the world, publishes an extraordinary number of books on the flora and fauna that he discovered, and then finally in 1859 writes a seminal work on the origin of species. Within about 10 to 15 years, most universities, and the sciences are becoming much more specialized, much more professionalized. After the Civil War, you now have departments of chemistry, departments of paleontology, biology, botany, zoology. Uh, the universities are being run now by scientists rather than clergymen. And one of the things I've noticed in reading the history at this time is there's a sense that religion is somehow losing. It's losing power. It's losing control. What it once ran, Harvard, for example, when founded, was designed to produce pastors for the church. The same with Yale, the same with Princeton. Well, these are becoming powerhouses of modern science. And those who are religious are seeing this as a real challenge. The world is changing, it's industrializing, it's becoming urbanized, and things are just not the way they were in the good old days. And so religious Americans saw as a conflict between religion and science, and they became quite afraid about what the future would be. And I think a lot of this has to do with their sense that somehow they were losing the control that they traditionally had over education. Okay, so why is it called the monkey trial? Well, of course, in the 19th century and even today, you have those who don't understand evolution and they say, oh, do you really think humans evolved from monkeys? I've had people ask me this question. And I have to tell them, no, human beings did not evolve from monkeys. If you try to explain to them the process of evolution, which is the best definition I've read, it's change in population genetics over time. When you tell them that, they would say, well, how could a monkey give birth to a man? This is a drawing from the 19th century, Charles Darwin, of course, being caricatured as a monkey. Darwin never said that we evolved from monkeys, but that became, here we go, another caricature. It says, Mr. Darwin, how could you insult the gorilla here because the man wants to claim my pedigree? So even during the time of Darwin's life, there's this connection between so-called monkeys or apes and that human evolved from them. Here's another cartoon from the early 20th century. It took millions of years. Darwin claimed to make a man out of a monkey. A company union can make a monkey out of a man in a few minutes. Still, it's just something that became ingrained in the society that Darwin's theory is that we were descended from monkeys. The anti-evolution crusade really developed during World War I and right after World War I. And it's part of what historians see as the fundamentalist modernist conflict. And in many ways, it's the rise of the culture wars. We have a lot of culture wars going on now. We Americans love having culture wars. But this is the response again to this growing change in America. You had millions of immigrants come in from other countries. You had, for the first time, a large number of Catholics in the United States. Protestants didn't appreciate that. You had a growing Jewish population numbering a few million. That wasn't appreciated by the Protestants. There was a sense that somehow things were going wrong and that Protestant Christianity would have to step up and prevent us from losing our civilization. Between 1910 and 1915, a very interesting phenomenon happened. There was a set of books called the Fundamentals that were published, 3 million copies published and mailed to thousands of clergymen and educators around the country. This is where we really get the phrase fundamentalism. And what the fundamentals argued were, and this is Protestant, by the way, the Catholics aren't involved in this, but this perception was, or the argument was, there are certain aspects of Protestant Christianity that cannot be questioned. The virgin birth is a scientific fact. The resurrection, the bodily resurrection of Christ is a scientific fact. The universe was created and man was created according to the book of Genesis. So if you look at the left, this cartoon, the fundamentalist, amen, brother, I believe in the full inspiration of the Bible. The modernists, and the modernists were the ones who people had great concern about. Yes, I believe in higher criticism of the Bible. Higher criticism was a German movement that studied scripture, not in terms of just its spiritual message, but in terms of language, culture, history, what conflicts and contradictions there were between scripture. And this cartoon shows this. It's black and white. You're either a fundamentalist, and the fundamentalists are right, by the way, or you're a modernist, and the modernists are wrong. So hence the origin of the term fundamentalist. These cartoons this is around 1920. There's a man named Pace who did a lot of cartoons. And I like this one on the left, the descent of the modernists. Again, it's them and us, the true Christians and the bad guys. It starts with Christianity, then it says no miracles, no virgin birth, no deity. And it descends down into what? Atheism. And if you're an atheist, you are immoral. And so the fundamentalists saw themselves as rescuing America and rescuing Western civilization from immorality. On the right, another Pied Piper, the path of education, Darwinian evolution being played. I always like it when Darwin is blamed for evolution. He wasn't the only guy who came up with the idea, but fundamentalists love to talk about Darwin. Disbelief in the God of the Bible. And of course, they're leading the children into this. It's always the children we have to be concerned about because they're being taught this science falsely so-called. This is a phrase that you see routinely used by the fundamentalists, that the scientists themselves are false and that the true science is to be found in Scripture and in the book of Genesis. The anti-evolution movement in the United States really began after World War I. It's unique to America. It's largely a conservative Protestant movement. And a lot of it came out from World War I and the horrors of that war. And as America, of course, the Americans blamed Germany for everything. And I'm not going to get into a debate about who was right or wrong in that war. It was horrific on all sides. Destruction like World War I had never been seen before, but Americans began equating German militarism with evolution and with atheism and with moral depravity. So their argument was the Germans were taught evolution. They became the barbarous, the Hun, as they were called, that we had to go over and slaughter in order to, if you remember, Wilson said, make the world safe for democracy. So the anti-evolution movement sought to outlaw or at least limit evolution in schools. If you look at this picture here, it's real interesting. T.T. Martin was the head of a group called the Anti-Evolution League. There's a reason he chose that term. There was an anti-alcohol group called the Anti-Saloon League, formed in Ohio in 1894. The Anti-Saloon League, by the time of World War I, was one of the most powerful political movements in the United States. It got the 18th Amendment adopted into the Constitution, depriving Americans of beer, wine, and liquor via constitutional amendment. It was an extraordinarily powerful political organization. And I think many Protestants said, if the Anti-Saloon League can be that powerful, if we create an anti-evolution league, then we can have that same power as well. And notice the conflict in hell in the high school. These were books written about, if you teach evolution in the high school, my God, the next thing you know, people will be out necking in Lover's Lane and that type of thing. In response to this, there were a variety of laws proposed in many states, a lot of them debated, but the one we're going to be discussing tonight is going to be the Butler Act of 1925. This is the act itself. I'm going to go into some of the details on it. It was written by a Tennessee legislator named Butler. He was not particularly well educated. He admitted that he really didn't know anything about evolution, but he claimed that he had read in newspapers that children who were taught evolution came home and told their parents they didn't believe in God anymore. So despite the fact he had no idea what evolution was, they had this law passed. And here's what's interesting. It says, it shall be unlawful for any teacher in any of the universities, normals, or other public schools of the state. So it really didn't outlaw the teaching of evolution per se. It outlawed it in public schools. So it didn't prevent anybody from owning a book on evolution or writing about evolution, or if you're a private institution conducting research into evolution. It was directed simply at the public school, and it was to teach any theory that denies the story of the divine creation of man as taught in the Bible. We're going to look at some of the details in a minute because it's interesting from a prosecutor's standpoint what I could and couldn't do with this law. Now, the other thing about this is what's the punishment? Between $100 and $500, but no jail time. This is very important. So it's basically a misdemeanor. You can get up to $100 to $500, and that today would be worth a few thousand for each offense, but no jail time at all. So if we look, this is Mr. Butler. He's a Democrat. He's a primitive Baptist. He came from rural Tennessee. And I think he was one of these men who was raised and simply told the Bible is true and very poorly educated. Literate, he could read and write certainly, but never any type of training in science or any advanced education at all, which was typical of many of the legislators in Tennessee. At this time, America was undergoing this transformation where the cities were becoming much larger. I think in 1920, the urban population surpassed the rural population. But rural America, terrified of losing power, is doing exactly what's being done today, and that is there's no redistricting. So rural America that has fewer voters still has more representatives, and that's how they're able to get laws like this through. So if we look at the elements of the offense, as a prosecutor, I talk about an element of the offense. If I have murder, for example, a person who knowingly or intentionally kills another person commits murder. There's basically three elements to it. Here it's to teach any theory. Well, theory is undefined. What do you mean by theory? That denies the story of the divine creation of man. Well, what's the story? What's deny mean? What's divine in creation? None of those are defined. As taught in the Bible, well, which Bible? The Catholics have a Bible, the Protestants have a Bible, the Mormons have a Bible, Jehovah's Witnesses have a Bible. And what exactly does this says as taught in the Bible? Well, what exactly does the Bible teach? And to teach instead that man has descended from a lower order of animals. Well, first of all, is that a correct statement of human evolution? I would argue it isn't a correct statement of human evolution. But here's what's real interesting. It doesn't prevent anybody from teaching that other animals or plants or bacteria evolve. It simply says you can't teach that humans evolve from a lower order. That's kind of a big hole in this. And it indicates to me that, once again, the people who wrote this simply didn't understand science at all. There's nothing in here about the creation of the universe, the age of the universe, continental drift, any of those ideas. Of course, continental drift as a theory didn't exist at that time. But it's interesting that it's directed only that man has descended from a lower order of animals. And as I read through this and I looked at some of the debates in the Tennessee legislature, which were limited, this is the type of thing that would appeal to a poorly educated Protestant, and then they would think they would have the problem solved. So it didn't prohibit modern cosmology, modern geology, modern biology, abiogenesis. It's a poorly conceived and ineptly drafted law. And here's the key point. No one thought it would ever be enforced. It was really thought by the legislature, this will make everybody happy. We've outlawed it. Let's get on back to something else. Because they thought, we'll just pass a law and everybody will observe it. The same idea was behind prohibition, by the way, which was incredibly naive. The prohibitionists often argued, well, people really don't like to drink. It's pushed on them. So all we have to do is outlaw liquor and nobody will drink a beer again in the United States. Obviously, a bit of a miscalculation. So nobody seriously thought that this law would ever be actually taken to trial. So why in Dayton and why John Scopes? Of all places, this small town, it's in the very south eastern corner of Tennessee. I visited there, been to the courthouse. They have a celebration every summer of the Great Monkey Trial. It's kind of fun to go to. So how did all this start? Well, here's Dayton. There's a map of it. So it's a county seat of Ray County, not very big, not much industry. Largest town is Knoxville, kind of a sleepy town. But what happened is that when the American Civil Liberties Union in New York was notified that this law had been enacted, the ACLU put ads in newspapers in Tennessee and said, if anybody gets charged with this crime, let us know and we'll come in and defend you. The ACLU was very interested in bringing up, among other things, First Amendment issues, separation of church and state, freedom of speech, and that, and of course, simply to defend science. So in Dayton, Tennessee, the drugstore no longer exists. The furniture there is there. They kept the furniture. But, and this says Robinson's Drugstore where it all started. And it's called the drugstore conspiracy. So what happened was George Rapelier, who was a local businessman, had noticed that Dayton was kind of in decline. There had been a post-war recession, businesses were closing. And because of prohibition, you would go to the drugstore and have a Pepsi Cola or a sundae or whatever. I'm sure you could get something harder somewhere else, but at any rate, in the drugstore, you couldn't. So he would meet with other civic leaders and discuss this new law and the fact the ACLU said that they would come in and defend it. And so here's the group who got together. This is John Scopes in the center. And what they decided on May 5, 1925 in Robinson's Drugstore is, hey, let's charge John Scopes with teaching evolution, call the ACLU in, and guess what? We'll be on every newspaper in the country. And that much did work out, but a lot of it had something that was kind of the law of unintended consequences. So who then is John Scopes? Well, born in Kentucky, he was a graduate of the University of Kentucky. He was hired as a football coach. He was not a science teacher. It reminds me of the old line, those who can't do teach, those who can't teach, teach Jim. He was a substitute teacher as needed, and he used a book called Hunter Civic Biology as a textbook when he was a substitute in the biology class. And he agreed to stand in the trial as a test case. He felt that this law was unfair and he felt that it needed to be challenged. Now, we're going to talk about Hunter's civic biology in a moment, But so he came forward and said, okay, I was a substitute teacher. I taught a biology course. I think I taught the theory of evolution out of Hunter civic biology. Now, Hunter civic biology is the state approved textbook in Tennessee. And guess what it allows to be taught? Evolution. This is another example of how inept the state of Tennessee was. If I'm a biology teacher and I use the state approved textbook, it includes evolution in it. But you pass a law saying that if I teach human evolution, I can be fined up to $500. So it's a matter of the left hand not knowing what the right hand was doing. And again, it's not unusual when state legislators meet. Indiana's is meeting right now, and I tremble in fear whenever those guys get together. Now, as a prosecutor, when I handled a murder case, I always talked about the scene of the crime. Here's the scene of the crime, since torn down, Ray County High School. And John Scope said, as best as I can remember, I was on this one certain day in the spring, I was the substitute biology teacher, and I taught evolution from this state-approved textbook. All right. So what happens? Well, it's a very unusual allegation of a crime. There's no complaining victim. There's no police investigation. He was never arrested or even booked into jail. Tennessee at this time had a very archaic system that allowed citizens to go in and basically issue their own summons if they claimed somebody had committed a crime. So, and remember, this is all kind of cooked up. They've been at Robinson's drugstore. Scope says, yeah, I taught evolution. They walk over, they swear out some affidavits, and charges are brought by grand jury indictment. But he's never arrested, never booked into jail. No police investigation. Nobody came forward and said, oh my God, my children are coming home saying that evolution is true. And trial is set in the Ray County Courthouse, July 10, 1925, with a man named Judge Walston presiding. So the prosecution team forms up because the ACLU is notified and the ACLU is bringing in their attorneys. And what is evident at this point is this is going to start generating a lot of publicity. Now, keep in mind, as a prosecutor, this is a misdemeanor case. Misdemeanors are generally tried by one prosecutor, usually a deputy prosecutor. And you normally get the case done in an hour or 2 hours. Look at what you have here. You've got the lead counsel, the Attorney General for the 18th District, Thomas Stewart. An assistant Tennessee Attorney General comes in. William Jennings Bryan, former U.S. presidential candidate, well-known, beloved by the American people, called the Great Commoner. This is his first jury trial in 30 years. He, quite frankly, has no business being in the courtroom. He was not a trial attorney. Brilliant orator, brilliant politician, beloved by the people. He had no business trying a case. His son comes in. Now, he was a former federal prosecutor, and then they had two more local attorneys, Sue Hicks, who is a man, by the way. It's the famous song, A Boy Named Sue. This is the guy. It's Sue Hicks, local counsel, and then Herbert Hicks. So you have a total of 6 attorneys on the part of the state to prosecute a school teacher, where the most you're going to get out of it is a $500 fine. This is Bryan, the Great Commoner, 3-time presidential candidate, strong supporter of prohibition, prominent in the anti-evolution movement, believed evolution bred atheism and immorality, a gifted public speaker, but he hadn't been in a jury trial for almost 30 years. So the defense team is organized by the ACLU. Now, the ACLU attorneys are actually lead counsel John Arneal from Tennessee, Dudley Field Malone from New York, Arthur Garfield Hayes, an ACLU representative, and then you always want a local counsel in, so Fred McElwee, local counsel, Tennessee attorney. I want to talk about Clarence Darrow a moment because everybody wants to talk about Clarence Darrow. Darrow was not part of the original defense team. When the ACLU was contacted, the defense team initially was going to be Neal, Malone, and Hayes, and then McElwee would be local counsel because you always want to have somebody licensed in the state as a representative there. Darrow essentially contacts Scopes and says, I want to be your defense attorney too. Now, Darrow is nationally famous at this time, particularly after the Leopold and Loeb case, and Scopes is thrilled by this. The great Clarence Darrow wants to represent me, come on board. Well, what we're going to see is Darrow kind of uninvited becomes part of this defense team, and you'll see how this causes some friction later on. So anyway, 6 attorneys for the prosecution, 5 attorneys for the defense, all over a trial that should take no more than an hour and a half to 2 hours. So here's Malone, Neal, and Darrow on the very right. Clarence Darrow, born in 1857. He really didn't go to law school. He read law. This is back in the old days when you could just read law. He supported Bryan in his early days because Bryan was actually something of a progressive. He represented labor leaders like Gene Debs, national fame for his defense of murderers Leopold and Lowe. Very outspoken in support of science and opposition to religious fundamentalism, controversial and combative. This is the kind of guy you put him in a courtroom and it's going to be like a bull in a china shop, but that's how he practiced law. And he was not the first choice for the ACLU because he's a self-confessed agnostic. And the fear was, this is just going to draw attention to, look, these are atheists and agnostics and they're out to destroy American Christianity. Darrow didn't care. He's going to charge in the defense here in defense of Scopes and science and in his opposition to religious fundamentalism. Nearly 200 correspondents descend upon Dayton, and this case rivets the nation. Now, of course, Dayton did okay with it. We'll see some of the cartoons later on. So Tennessee trial, this is from a newspaper in Detroit is reporting on this. Of course, the hotels were overflowing. A lot of money coming into Dayton. Everybody's quite happy. It looks like our drugstore conspiracy is working well. This is a cartoon about William Jennings Bryan. Bryan was seen as something of an outcast. He had opposed World War I, and you see in Bill Bryan's zoo, you see pacifism talk 16-1, prohibition 16-1 is the famous. He was a silverite. He wanted silver and gold to be at a 16-1 ratio. So here he is. This is not one that's really endorsing Bryan. He's kind of a political outcast at this point. So now he's chasing down evolution to put it in his menagerie. What would their verdict be? Once again, the monkeys. Let's put the money. It's this recurring theme about monkeys is rather interesting. Monkey business. Here we go. Dayton, the Dayton, Tennessee. What's happening? Money is pouring in. So this again is a rather cynical look at what was really happening in the trial. Okay, trial strategy. So what's the prosecution strategy? Now, the AG Thomas Stewart is a professional prosecutor. And he wants to have a narrow prosecution focusing just on guilt or innocence and prevent the defense from presenting any evidence about the science of evolution or differing interpretations of the Genesis creation story, which is going to be a valid defense because if we're supposed to have the Bible's story, well, which story are we talking about? So he wants a very narrow focus to this. Simply, did he or did he not teach evolution, human evolution? Bryan conflicted with this. Now, remember, Bryan is not a professional prosecutor. He wants to turn it into a morality play. He said with this degree of national publicity, and Bryan loved publicity. There was never a reporter or a camera that he wouldn't refuse to get in front of. He could turn this into his life's work. He had managed to abolish alcohol. Now he's going to abolish evolution. So his performance here is not going to be so much as a trial attorney, but as an evangelist. He's going to use this national publicity to further his anti-evolution cause and equate evolution with atheism and immorality. And boy, what a great target to have. You've given me Clarence Darrow. He's already known to be either an agnostic at best or an atheist at worst. Everybody's hoping there's going to be the clash between these two guys, Bryan representing fundamentalist Christianity and Darrow representing science and reason. Okay, trial strategy defense. Number one, attack. The Butler Act is unconstitutional under the U.S. and Tennessee constitutions on a number of grounds: separation of church and state and freedom of expression. Argue in favor of academic freedom. Put on expert testimony to explain the science of evolution, since obviously nobody in Tennessee seemed to understand it. And they wanted to present religious testimony establishing different interpretations of Genesis. Who's to say what Genesis means? Lots of different churches, lots of different avenues of approach in interpreting it. So they're wanting to have a reasonable and moderate defense that evolution does not equate to atheism and immorality. That's why they had such concerns about Darrow's role and his courtroom persona. Now, they were ready to lose a trial. They pretty well anticipated that the trial court, and this is what you have to do sometimes if you have a constitutional challenge, it would be unlikely that the trial court would hold this law to be unconstitutional. You want to get the case up on appeal to the Tennessee Supreme Court, where you have a better chance of making those constitutional arguments. So the defense is wanting to be reasoned. They want to be moderate, but they want to get their evidence on so they can get this before an appellate court and get this statute declared unconstitutional. Here's the Ray County Courthouse, classic old-fashioned. I've practiced in places like this in southern Indiana, one big courtroom, no air conditioning, of course. And it was a scorching hot summer. This is the modern courtroom, and it looks exactly the way it did with a few changes, as it did in 1925. It's a very strange arrangement for a courtroom. When I went in there as a trial attorney, I didn't care where the jury was situated vis-a-vis where the witnesses would be. And you'll see some pictures of this. This room became absolutely packed. But this is the courtroom as it looks today, looks largely like it did in 1925. So the great commoner arrives in Dayton, and everybody is thrilled. Dayton is now someplace, everybody's talking about Dayton, and the hero of the people, William Jennings Bryan, appears in Dayton, Tennessee. Now, of course, some people look at this a little cynically. Dayton, my first real bath, gee, and it great publicity, basking in the glow of William Jennings Bryan. So a lot of cynical cartoons made about this whole situation. Okay, the beginning of the trial of the century. This is a photograph of the courtroom, and it's interesting because, first of all, they allowed photographs in the courtroom. Normally, that wasn't allowed. But if you look in the very center bottom, almost, you can see I'll put my cursor on it. I don't know if that's, you can see it, probably not. There's a radio microphone. This would be one of the first radio broadcasts. WGN from Chicago brought its radio. This was unheard of, to have a trial broadcast over the new medium of radio. So, morning session. Now, mind you, this case should get over in one day. It doesn't. It begins with prayer. Darrow is not happy about this, but it begins with prayer led by the judge. They have to reconvene the grand jury because of some technical problems. The judge reads from Genesis, and Scopes is re-indicted, and there's preliminary arguments over defense expert witnesses. So, afternoon is jury selection. Darrow is brief in his voir dire. Voir dire means to speak the truth. This is the process by which you interview prospective jurors. What do they end up with? Well, not surprising, 12 white males, 11 are farmers, and 1 is a clerk. 7 are Baptists, 3 are Methodists, 1 disciple of Christ, 1 unaffiliated. All were religious, but knew little to nothing about evolution. So not surprising, a rural jury in Tennessee being constituted in that fashion. And keep in mind, because of Jim Crow, African Americans could not vote. So they were going to be excluded from the jury automatically because they had no legal rights at that time. So evolution trials, once again, the publicity. Darrow's in his shirt sleeves, courtroom is crowded, overflowing to the steps and corridor. Bryan gets a round of applause upon entering the courtroom. I mean, this is like it's a basketball game or something. So, of course, all the local people are thrilled. Bryan's going to come in, and already, notice here, Bryan is not lead prosecutor. The prosecuting attorney for Tennessee is. Bryan's getting all the publicity. Darrow is not lead counsel for ACLU, but he's getting all the attention. So all of a sudden, this case, and I think there were those who realized what was going to happen, is this case is becoming bigger than John Scopes. It's going to be about Bryan versus Darrow. Here's the trial jury. What a happy looking bunch of people. And again, this courtroom had such an odd design to it, but there were so many people crowded into it. These are the 12 men chosen to hear the case. People really wanted to get on this jury. This was the talk of the town. They thought, wow, I'm going to get a guaranteed ringside seat to watch this trial. What's interesting is, as it turned out, the jury spent more time sequestered, taken out of the courtroom so they couldn't hear the argument, that if you were a reporter, you heard more about it than the jury did. So as the whole thing turned out, the jury was a bit disappointed because they missed all of the fireworks that were occurring in the courtroom because the judge would order them, the argument made outside the presence of the jury, which is not unusual if you have a matter of evidence that one side's attempting to present, and you don't want the jury to hear that unless proper foundations are laid. So these poor guys had to spend most of the time in a small room off the main courtroom. So day 2, they've got a jury trial. Morning has pretrial motions. The judge retires the jury. So once again, they're out of the courtroom. The defense moves to quash the indictment on the grounds that the Butler Act violates both U.S. and Tennessee constitutions. Now, Darrow's not really involved in this part of the argument here. This is much more technical constitutional arguments. They break for lunch, come back, continuing arguments on the motion to quash. Here again, a picture of the courtroom. Bryan is on the right there consulting with an individual, and you see how packed this room is. Day 3. Now, this is the trial that should have been done on day 1. This is day 3. Morning session, again, begins with formal prayer. Darrow objects. And this is where you're going to see Darrow begin getting into it with the judge. The judge refuses to stop the prayers, but the judge does stop the court long enough for photographs to be taken, including of himself. So Judge Ralston is thrilled by the fact that there's publicity and we get an opportunity for him to get a national press as well. Afternoon session begins at 2:30. The defense presents a petition from Unitarians and Jewish clergy to take part. The judge refers the matter to a pastors' association. Then he expresses concern about leaks to the press. Somebody is talking about some of the evidence and apparently is ending up, and so he's concerned about leaks to the press and how that might prejudice the case. So day 2, what's been accomplished? Not much. Here's Judge Ralston posing for photographs. Very important for the judge to be recognized nationally for this major trial that he's appearing on. More photographs in the courtroom. There's that radio speaker you can see in the middle of it again. Mr. Bryan is about to the left of that. Day 4. Now, again, I've done murder trials that took 4 days. This is a misdemeanor, and they still haven't had a single bit of evidence presented. They do have a Unitarian pastor. I remember a joke, how does a Unitarian begin a prayer, to whom it may concern? The defense continues to object. The judge overrules the objection. At some point, somebody called Darwin an infidel. He gets upset about this and complains about it to the judge. The judge has reached a decision and basically has an hour-long statement denying the motion to quash the indictment. So the judge says the Butler Act is a valid expression of the legislature's authority to set the curriculum in public schools, found no violation of separation of church and state. Now, the defense expected that would happen, but they've made their record so they can argue what's called preserving error and get that up to an appellate court later on. So day 4 in the afternoon, finally reconvenes at 1:30. Scopes pleads not guilty. There's opening statement. Prosecution is very simple. Scope broke the law. It's remarkably short, not impassioned. It's very reasoned. He explained the statute. He explained what the evidence was that he expected to present. Very standard opening argument by the prosecution. The defense is done not by Darrow, but Dudley Malone. And Dudley Malone is very different than Darrow. Malone is a very reasoned man. He's less passionate, less angry than Darrow would be. But the essence of his argument is science is not the enemy of religion. So the state finally presents its case in chief. There are 4 witnesses. The Ray County Superintendent of Public Instruction establishes that's John Scopes. Yes, he was a teacher here. Yes, we employed him. So you establish that he is an employee of a public school. You have to do that to prove the statute. 2 students are brought in, 14 and 17, who claim that I was in the classroom and he read to us from some book something about evolution. The evidence on whether or not Scopes actually taught evolution has always been a point that's debated by historians. And when I read through the transcript, which is available online, this is drawn from the actual court transcript, I wasn't necessarily convinced that anybody was too concerned about whether or not Scopes had really taught evolution and what that meant. Chairman of the Ray County School Board testifies once again to establish it's a public school and that type of thing. Only 2 exhibits are introduced. One is Hunter's Civil Biology. Now remember, that's the state-approved textbook. This is the textbook that says, use this when you teach, and it has evolution in it. And exhibit 2 is the King James Version of the Bible. So the state rests. And this is, Malone is getting up, he's over to the right, and the defense is now going to begin the presentation of their case. So it calls as its first witness, Dr. Maynard Metcalf, a zoologist from Johns Hopkins University, one of 8 science defense experts and 4 defense religious experts. States objects to the expert scientific testament, arguing that that's what evolution means is irrelevant to the question of whether or not he taught it. Judge Ralston orders the jury to retire. Once again, they have to leave, so they're missing all the fun arguments. They thought they were going to have the front row seat. They didn't have one after all. Here are the defense experts. It's interesting. You'll see Dean of Divinity School of Chicago, a Baptist, a professor of anthropology, just a rabbi they bring in, pastor of the First Methodist Church, state geologist. So they were going to be heavy on the science to explain what is evolution, and at the same time bring in differing views, a Baptist view, a Jewish view, a Methodist view on what the book of Genesis means. So pretty well reasoned defense there, but the issue is, will the judge allow this testimony for the defense? Here's Mr. Metcalf, who's going to be the lead uh, witness for the state or for the defense. And normally you start very strong. So my expectation would be that he would be someone who would be able to explain in reasoned and dispassionate terms what scientists mean when they talk about evolution. So day 5, the jury's still retired. Once again, there's prayer. Dr. Metcalf briefly returns to the stand. Darrow now asks him to explain what evolution means, and Stewart objects. So there's a break, and you go into the afternoon session where they continue to argue back and forth against the use of expert witnesses. The state doesn't want the jury to hear any of this. It's just, was evolution taught, yes or no? They don't want to hear all the, what does evolution really mean? And what does Genesis really mean? And this is where Bryan, in his response, reaffirms his duel to the death quote. Here he is making a point. He was a very passionate public speaker, apparently quite spellbinding. But again, he's wanting to make this more of a bully pulpit for religious purposes, make it more of a sermon than an argument made in a courtroom. And again, to reiterate, he hadn't been in a courtroom for 30 years. And if you look over to his right, I'm assuming he's holding a Bible, you see the WGN. So this is being broadcast live over the radio. So day 6, short session, jury is retired. Ralston rules against the defense and does not allow further expert witnesses. So the defense has been gutted. There's an argument about preserving the record because the defense attorneys want to make sure that the appellate court can review what they were going to argue. So the court rules, okay, read the statements into the record, but no cross-examination by the state. So the stenographer is going to have the record of what they were going to testify to. Darwin now begins to kind of cross the line. And he begins to complain about what he claims is bias against the defense, and he really means bias against himself. And the court recesses at 10:30 on a Friday. So we go over the weekend. So this is week 2 of a trial that should have taken 3 or 4 hours. 9 o'clock again. Stunning move. Court holds Darrow in contempt for earlier comments. Now, contempt is a remedy a court has for a witness or an attorney who is out of line in the courtroom and disruptive. Now, he holds him in contempt, but he doesn't decide on the punishment. And generally with contempt, there's 2 things you can get. You can either be fined or you can be put in jail for a period of time. Darrow is smart. He makes a lengthy apology to the court. I'm sure he had to eat a lot of crow in that one. Ralston, citing Christian principles, forgives Darrow and withdrew the contempt citation. So Darrow understands he's crossed, and I've read what he said here. Darrow was clearly out of line, and I'm sure the ACLU attorneys were not happy with Darrow at that point because Darrow was famous for getting into it with judges. And I can tell you, my father was a judge. Don't argue with a judge. Listening to Darrow apologize for contempt of court, clearly the defense team does not look very happy in this situation, but Darrow's insisted on coming in, and he at least recovers and doesn't go to jail and isn't fined. Here's the newspaper demand Darrow's punishment for clash with judge. But as I said, the judge chose to withdraw the contempt citation and did not impose any punishment. That afternoon, the judge moves the trial outside. It was scorching hot inside, and it was concerned that there were so many people in the court, the judge was afraid that the floor would actually collapse. And at this point, a lot of people thought the trial was over. The defense had been gutted. Darrow had apologized. A lot of people left thinking nothing really big was going to happen, but everybody moved out. And by the way, it's hard to see, but on the side of the courthouse, it says, read your Bible. So this is one of the points that Darrow would get upset about, like how can you call this fair and neutral when you got a big sign on the courthouse saying read your Bible? So many believe the defense does introduce a copy of the Catholic Bible and as an exhibit, but the court denies the instruction of a Hebrew Bible. And this is where the case completely gets turned on its head. In an absolutely bold and stunning move,
Clarence Darrow calls Bryan to the witness stand. Now, remember, it's still the defense case in chief. It's been gutted because the court has ruled not going to hear anything about evolution, not going to hear anything about the book of Genesis. Darrow says, William Jennings Bryan claims to be an expert on the Bible. I want to call him as a defense witness. That is unheard of. It was not a spontaneous decision, though. And why it's unheard of is the rule is in all American courts, you cannot be an attorney and a witness in the same trial. You cannot do that. But what had happened was Bryan and the ACLU team over the weekend, they planned this because Darrow's sense of Bryan was Bryan wanted the limelight. Now, Bryan didn't have to take the stand. Bryan could refuse, I'm an attorney, I can't be a witness. But he was betting that Bryan's ego to orate would overcome his better judgment, and that's exactly what happened. So Darrow practices questioning Bryan by using geologist Kurt Mather to play the part of Bryan. So the defense did not sit around this weekend doing nothing. They prepared. And Darrow was careful. He asked no questions about the New Testament. It was all questions about the Old Testament. So the competing strategies. Darrow wants to show Bryan relies on interpretation for understanding. Well, of course you have to. And if understanding the Bible requires interpretation, there could be several interpretations. And therefore, evolution might not necessarily conflict with the Genesis account. Darrow substitutes Bryan for his own experts, which the court disallowed. It was a brilliant move on his part. And also, Darrow wants a showdown with Bryan, and Bryan wants the same. And guess who else wants it? The public wants it. This is what they're waiting for. This is the Roman crowd waiting for the Christians and the lions. The lawyer for the state objects, but Bryan says, no, that's fine. I'll get up here and testify. And Bryan intends to demonstrate his faith in Scripture. Bryan also plans to turn the tables and put Darrow on the stand and question him. So, and once again, it's extraordinary for an attorney to be called as a witness, but Darrow really played on Bryan's ego here. And here's the outside setting. This is Darrow and Malone for the defense, and witness chairs for the jury. This is one of the few photos taken. Actually, Bryan is sitting and Darrow is confronting him. Darrow liked to pull on his suspenders while he was doing his direct examination. Darrow versus Bryan on the Bible. Scope's lawyer puts commoner on stand as witness. He was always called the great commoner. So, and this is Des Moines Register. So we're already seeing this is front page news across the country. More information explains the Bible creation story. Darrow cited for contempt. Biggest day of the trial at a glance. So the American public is really lapping this up. Another close-up of Bryan and Darrow, this great confrontation between the two. So what really happened, there's the crowd outside the courthouse. Once news spread that it was really happening, people started coming back to the courthouse because this was the moment they had really waited for. Now, what's interesting is what Darrow establishes is that Bryan is not a 6-day creationist. He's really not that much of a fundamentalist. Bryan espouses what's called a day-age theory of Genesis. And the day-age theory says, you know, a day could be anything. It could be 24 hours, but it could be millions or billions of years. So this idea that Bryan was just a dyed-in-the-wool strict fundamentalist is not correct. He was willing to say, well, there is room for interpretation here. Yes, the earth might be millions of years old. It might be a few thousand years old. He said, I really don't know, but this day-age theory gave room for interpretation. And that, of course, was one of the things Bryan was wanting to establish is it is a matter of interpretation. But it's real interesting. Bryan was not a 6-day creationist. As I read the transcript, and the question you would have is between Darrow and Bryan, who won? My interpretation is there's no real winner to this. Neither of them came off well. Darrow occasionally came off snarky. Bryan was brilliant in his use of the English language. At one point, Darrow talked about the age of rocks, and Bryan's response was something to the effect of, I'm more interested in the rock of ages than the ages of rocks, and that got a great response from the spectators. So, day 8. Now, the jury hasn't heard this. Once again, the jury has been taken out. The morning session, the judge strikes Bryan's testimony. So all of that sturm und drang for what? Absolutely nothing. And Darrow does not take the stand as Bryan had hoped for, because Bryan at this point, once the defense rests, Bryan wants to do what's called rebuttal, and he wants to call Darrow to the witness stand. Darrow makes an extraordinary move here, and he asks the judge to direct the jury to convict Scopes. And he does that to waive argument, because here's what Darrow knew. Bryan had prepared a great speech. Bryan had been working for a long time on what was going to be this wonderful speech about the evils of evolution and the wonders of Christianity. Darrow didn't want him to make that speech, and he figured the jury's going to convict him anyway. So by asking, and this is the strategy here, he asked the judge, order the jury to convict my client, and I waive argument. Now, in Tennessee at this time, if the defense waived argument, the state couldn't make an argument. So there is no closing argument. The jury's brought in. The judge says, I instruct you to convict him. They go out for 9 minutes and they convict him. The judge imposes a $100 fine. That's about $1,400 today. No jail time because it's not provided for in the Butler Act. So this great confrontation between Darrow and Bryan turns out to be nothing. It really kind of fizzles, especially because Darrow, and this is where Darrow is a much better attorney than Bryan. Bryan should have listened to the experts. Bryan had no business testifying, and Bryan didn't realize that Darrow might do something as brilliant as just go ahead and convict my client, because they want to get it to the Supreme Court anyway. And they figure we're going to get a conviction. Why not direct the jury to convict? And I pull the rug out from under Bryan, and that's exactly what happens. So Bryan is unable to deliver it's later published, but he's unable to deliver his great speech. John Scopes at sentencing, I have been convicted of violating an unjust statute, says John Scopes. So who are the winners and losers? Once again, we have the monkey trial here, guilty, the Scopes trial. Bryan died in his sleep July 26, 1925, just a few days after the trial. Some have tried to say that the trial caused him to die. He was very overweight and suffered from diabetes and was not particularly healthy and was famous for eating just enormous meals. And so he did nothing to treat his diabetes, and he died just a few days after this. Ape war to high court. Once again, we see this. This is Topeka, Kansas. So it's going to be the case and the publicity continue. The appeal. They're given 30 days to perfect the appeals, what it's called. There's more maneuvering among ACLU attorneys because they're unhappy with Darrow. They're just not pleased with what he did. And local counsel's given primary responsibility for the preparation of the appeal, which makes sense because he's the Tennessee attorney. However, John Neal failed to perfect the appeal within time, and so the Supreme Court of Tennessee refuses to consider arguments on the admissibility of expert testimony. So that issue, the Supreme Court, because John Neal failed to perfect that means getting the record prepared and presented to the court within 30 days. The court said, we refuse to consider arguments on this. The decision was a 3-1 decision, 1 concurring opinion, 1 dissenting. The court held the Butler Act was not void for vagueness. So there's one of your constitutional arguments. They argued the court held the Butler Act did not violate due process. Scopes is a public school teacher. And the argument here is the legislature has the authority to determine what shall be taught in schools. And the court said, we don't see anything in this that gives preference to any one religion. So they lose their ability to argue on the admissibility of expert testimony. On the constitutional issue, the court rules against them. However, the conviction ends up being reversed. So defense loses and loses and loses, but the Tennessee Supreme Court says, wait a minute, Judge Ralston committed reversible error when he imposed the fine. The Butler Act required that the jury impose the fine. Now, that is a blunder on the part of the trial court of extraordinary magnitude. And I've debated, I can't find anybody who can resolve this. Was Judge Ralston that bad of a judge? Or did he do this on purpose? I just don't know. But the fact that all he had to do was tell the jury, go back and debate amongst yourselves between $100 and $500, and you tell us. And instead, I mean, the judge had to have the statute in front of him. Couldn't he read the thing? So the whole conviction gets reversed. It's thrown out. John Scopes is effectively not guilty. It's going to be sent back to the trial court. But here's the most extraordinary thing that I've ever read in a statement. This is the Tennessee Supreme Court saying, we see nothing to be gained by prolonging the life of this bizarre case. On the contrary, we think the peace and dignity of the state, which all criminal prosecutions are brought to redress, will be better served by an entry of nolo prosequi, which is the Latin phrase meaning I don't prosecute. In prosecutors, we call it a nollie. Herein, such a course is suggested to the Attorney General. This is the Supreme Court, Tennessee saying, just put an end to this whole thing. Normally what would happen is you would refile the case. And that's exactly what occurs. The case just ends. John Scope's conviction is reversed. All this time and effort and money spent by the state of Tennessee to accomplish absolutely nothing. So what's the legacy? Well, Scopes is never reindicted or retried. By 1930, the evolution crusade has fizzled out. Only the states of Tennessee, Arkansas, and Mississippi criminalized the teaching of evolution. So the anti-evolution crusade fails. John Scopes is the only person in American history to be prosecuted for teaching evolution, and the Butler Act was finally repealed by Tennessee in 1967. So who won? Well, the popular idea is that Christian fundamentalism is shown as backward and ignorant. Most universities and colleges continue to teach evolution. At the local level, the topic was simply avoided. Science, of course, progressed on genetics to modern evolutionary synthesis, and discoveries by paleontologists advanced the understanding of evolution and provided a secure foundation of evidence. And the creationists largely retreated into their own institutions. Until 1957, Sputnik and America panics. We don't have enough science teaching. So what do? Science is now all the rage to be taught, including biology, including evolution. And so the evolutionists, the fundamentalists shift from outlawing evolution to teaching what they call scientific creationism. So rather than trying to make it something illegal, why don't we teach creationism in the courtroom? And they faced the reality that the anti-evolution laws were ineffective. So they flipped the coin on it and said, well, if you're going to teach evolution, we want our version to be taught in schools as well. And this is before the days of intelligent design. The phrase used was scientific creationism. U.S. Supreme Court rules on this issue in Epperson versus Arkansas, a first U.S. Supreme Court case to consider evolution. It's a landmark victory for science in the courtroom. 1967, Tennessee legislature repeals the Butler Act. 1968 rules that Arkansas's law, anti-evolution law, still on the books, never enforced, that violates separation of church and state. So in 1968, what Darrow and the ACLU wanted the court to rule on in 1925 is finally the U.S. Supreme Court says anti-evolution laws are a violation. And then the Mississippi Supreme Court in 1970 holds the Mississippi anti-evolution statute invalid. Epperson versus Arkansas, a biology teacher challenged the statute, and basically the U.S. Supreme Court, after 43 years, struck down all the anti-evolution laws. And the anti-evolution law was intended to protect, the Supreme Court found a particular religious teaching, the Book of Genesis, violates constitutional principle of government neutrality in matters of religion because they chose the Book of Genesis. Why not choose the Book of Mormon? Why not choose the Bhagavad Gita? Why not choose something else? So major ruling in Epperson versus Arkansas. But they don't give up. In 1961, a book is published called The Genesis Flood. 1963, Creation Research Society is founded. By 1970, they're publishing a creation science textbook. 1972, an Institution for Creation Research is founded. But creationist movement suffers from divisions based on personalities and doctrine. Everybody wants to be the one who's right, and they get into enormous fights back and forth about who should be leading the continued struggle against evolution in schools. This is an idea of how complex this is. You go all the way from young earth creationists all the way down to day-age creationists, which is what Bryan said he was, progressive creation. There's old earth, there's young earth. It's a whole spectrum of different religious beliefs, even by those who hold the Book of Genesis is correct. So there is no one type of fundamentalist. There's a spectrum of fundamentalism. 1975, U.S. Court of Appeals strikes down a Tennessee law requiring biology textbooks to give equal emphasis. Tennessee wouldn't give up. Rather than making it illegal to teach evolution, Tennessee says, well, if you're going to teach evolution, teach the Genesis account. U.S. Sixth Court of Appeals strikes this down. In Indiana, we had our own monkey trial in 1977, Herndon versus Camel. The Indiana Textbook Commission adopted a biology textbook, including that one, Biology, A Search for Order and Complexity. And a Marion County Superior Court judge held trial on it and found that creationism as a science is a sham. And the prospect of biology teachers and students alike forced to answer and respond to continued demand for correct fundamentalist Christian doctrines has no place in public schools. So a pretty strong statement. So then they're going from anti-evolution laws to scientific creationism. 1981, Louisiana passes a balanced treatment. The argument is that if you're going to teach evolution, you need to teach, and the phrase now is creation science. 1982, U.S. District Court holds an Arkansas state law requiring the teaching of creation science violates the First Amendment to the Establishment Clause. They're not giving up. 1987, Edwards versus Aguilar, U.S. Supreme Court rules that Louisiana law violates the First Amendment because it's not neutral in matters of religion. 1990, Discovery Institute is founded. This becomes the center of intelligent design. They give up on creation science and decide to drop out the word creation and just put in the word intelligent design. And just 19 years ago, the major case, U.S. District Court, Kitzmiller versus Dover Area School District, found a federal court ruled that, quote, intelligent design, he ruled specifically, it is not science, violates the First Amendment because intelligent design cannot uncouple itself from its creationist and thus religious antecedents. And so back to where it all started again, this is this historical marker outside the courthouse. This is the interior. I had a chance to visit with my wife. The basement is dedicated to this. And of course, you see monkeys everywhere. Monkey Town Brewing Company, they have a small brewery there. So of course they call it the Monkey Town Brewing Company. They have a Scopes Fest now. So it's kind of fun to go to. Here's the reenactors doing the trial. There was a proposal to put a Clarence Darrow statue in, and there is a statue of William Jennings Bryan. But when a group proposed putting, and this is just the last few years, this is 2016, people's heads exploded because they said, we can't have the atheist out there. Well, there was a fight about it. And so what ended up happening, William Jennings Bryan on the left is finally joined on the other side of the courthouse by Clarence Darrow, locked in their eternal struggle of the arguments for science and evolution against the arguments for the Bible. And if you notice, the courthouse still has the sign on it, read your Bible. So it's a real interesting historic place to visit. Major defeats for the creationists are Epperson versus Arkansas, Edwards versus Aguilar, and Kitzmiller versus Dover Area School District. So time and time again, creation science has been found to violate the Constitution, and intelligent design has been ruled to not be science, but creationism. What's the status in 2024? Well, the Dover decision was an astounding and embarrassing defeat. Many of the personalities, Philip Johnson, who was a big intelligent design advocate, an attorney from California and law professor, has died. Efforts within state legislatures continue. As I said, in Indiana, we had one, but the win in Dover gives politicians reason to act cautiously. Intelligent design has failed as a scientific theory and remains isolated from the scientific community. So it seems to be dead in the water. However, I did go online and find that they just won't give up. The state of West Virginia has a law that says requiring teacher grade and allowing the teaching of intelligent design. Teachers in public schools that include grades kindergarten through 12 may teach intelligent design as the theory of how the universe and or humanity came to exist. So it's interesting that once again, their science is terrible. Humanity came to exist. What about all other life? What about animal species, plant species? They're still so focused on humanity, but allowing intelligent design is, even though federal courts have ruled intelligent design is purely religious and is a violation of the First Amendment. That is the story of the Scopes trial that began in a drugstore and continues to rage to this day. If anybody has any questions, please let me know. And thank you very much for joining me tonight to discuss this
very, very interesting aspect of a case from American law.
Thank you so much, Hal. That was really great. And it puts a lot of things in context, which we appreciate. I'm Kenny Coogan. I'm the CFI Education Coordinator, which includes TIES and 2 other programs, which we're going to talk about in just a minute. Our website is tieseducation.org. We're very active on Facebook. I usually post 1 thing a day, and these are non-political, positive stories about science and how it relates to evolution. We have a good YouTube page as well. All of our past webinars are posted there. And if you are teaching K through 12 science, you can go to our playlist on that YouTube page, and you will see that I have created playlists for different themes. So we have a playlist for genetics, a playlist for natural selection, a playlist for human evolution, and et cetera, et cetera. And you are welcome to use those in your classroom. On our website and on our Facebook page, you will see our upcoming webinars. We like to have 1 webinar a month from September through May during the school year, and you are encouraged to invite your students. We have a couple coming up for this school year, and Hal's presentation was great. It kind of ended our Darwin Day festival. We had a webinar last week, and then this past Monday, and then this one. And all of our resources are free. All of them are editable. How do you say that word, Bertha? You can edit them. They're on Word, they're in PowerPoint, and we want you to make them your own. You can add your name to them. They have lesson plans, so if you need to submit something to your admin, feel free to type it up, and you can easily do that. If you've already taught something, or if you feel like you need to add something, you can add a slide. It is for you. All of the resources are made by teachers for teachers. All of our resources are free except for one, and that is our book. And that is because we have to pay to get it printed. It is called On Teaching Evolution. It was written by members of the TIES Corps, and it offers advice and sample lessons plans for fellow science teachers. There's over like 200 years worth of experience in the classroom. The foreword was written by Richard Dawkins. And just for everybody who is attending this and everybody who's watching this as a recording, we have a special. We have a BOGO special. Buy 1 book, get the second one for free. You can go and buy that at tieseducation.org. Now, that was TIES. We have 2 other programs. One of them is Science Saves. Science Saves is a nonpartisan effort to promote science appreciation by highlighting the many ways science has improved our lives. The website is right here, and we have K through 12 lessons, and they're in all of the different subjects. So we have a math lesson, we have language arts, social studies, elementary, all the way up through 12th grade. And just like TIES, you can edit them, download them, and they're good to go. Part of Science Saves is that we're trying to get a National Science Appreciation Day. We have many states who have signed on. If you want to sign up, you can click that link. And the day that we've proposed is March 26th, which is when Jonas Salk revealed the successful development of his polio vaccine. And we also have a senior high school scholarship. We have been funded for 5 years, and this is like year 3, so we're good for at least 2 more years, and hopefully we're going to be funded for even more years. First place winner receives $10,000. Second place gets $5,000. This year, the deadline is May 6th, and what they have to do, the high school senior, is to make a 30-second video about how science has improved their life. And the last program that I'm going to talk about is Generation Skeptics. And this program aims to develop and foster an understanding of the world through inquiry-based learning. All of our resources here are also free. We have K through 12 lessons. And if you are looking for an expert to zoom into your classroom to tackle any of these topics that you see on your screen, you're welcome to contact us, and we can set you up. At the beginning, Joan said, religion or consensus superstition is declining. Thank God. And that got quite the laugh. Hal, do you think that's true? Do you think religion and consensus superstition is declining overall?
It depends on where you are. As I said, I've served 2 combat tours in Afghanistan, and I can tell you it's 99% Muslim, and it is wildly conservative. Although the Afghans have a saying, which I found kind of funny. They said, "We believe half the Quran." And I said, "Which half do you believe?" And they were like, "Yeah, what day of the week is it?" So in the United States, certainly one of the groups that I've given some talks on are the so-called nuns, N-O-N-E-S. Indiana is estimated to be 28% none. So it's 25 to 30%. So I think in westernized, urbanized, educated societies, yes, you do see that decline. What's tragic, though, is in areas, particularly those suffering from great illiteracy and poverty, you have, and of course, the great thing for a politician is to have an ideology you can exploit. And that's what I see how religion can be used. But in the United States overall, I mean, the Baptist church have admitted they're losing members. The Mormon church is admitting they're losing, young men are leaving the Mormon church. There are parts of Utah where there are more unmarried Mormon females, which I guess based on the good old days would be an advantage. So I do see that happening in the United States, and that's caused real fear on the part of those who believe that they are losing the control that they want to have, and that works into Christian nationalism and all of the problems that we're facing, real challenges to our democracy. But I would say overall, the churches are, I don't think the churches were ever packed in the United States. I've read a couple of really interesting histories on early America. It's estimated like at the time of the Revolution, barely 25% of the population went to church. You didn't have a church. And Americans just didn't care that much about it. So we have a lot of myths about Christianity in America, but I would agree that it's certainly, it's on the decline, and the religious don't know what to do about it.
All right. The lemon test seems to be in danger. What do you think about this? Can our courts be held accountable?
Say that again?
The lemon test
Yes.
seems to be in danger. What do you think about this?
I would agree. The current Supreme Court, I'm sure, has several, I'm sure they've already drafted the opinions. I mean, this stuff, they have been working on this for years. And the lemon test is a 3-part test that was developed in 1968 that basically the intent of it is to look at a statute and say, does this advance religion or impede religion? Because the whole idea is that the government is to be neutral in religion. And does it unnecessarily entangle government and religion? Indiana, for example, is proposing that there be chaplains in public schools, that there be chaplains. And I've been asked to testify against this. Well, are they going to be paid by tax money? Why am I paying for a Mormon chaplain if I'm a Catholic? Are you going to have Muslim chaplains? Are you going to have, so I think the lemon test is in great danger. And my fear is that even with this intelligent design, if it went up to our current Supreme Court, I'm sure you've got 4 justices who would rule the way the Tennessee Supreme Court said, which was, hey, that's up to the legislature. Whatever they want to teach, they can teach. Let them do it. And that was what the Tennessee Supreme Court really came down, at least on that constitutional issue. So yeah, when I read their decisions and I read them, I am not at all optimistic about what may happen.
All right. Well, I don't know if should we leave it on that note, Hal?
Well, you got a free lawyer here, so take advantage of me while you can. But it's a real interesting topic, and I think we just have to all be aware at the local level. As I work, Reba McIntyre is the director of CFI. She's a former teacher, and so she and I have gone over and testified before on some of these issues, and I think you just have to really be aware of it. In my experience, I think embarrassment works better than anything else. Just like seriously, this is what Iran teaches. Is this you want to be a cutting edge like Iran? So,
Mhm.
but
Right.
yeah, it's an interesting time.